woman intermingled. Never ever. Now, the explanations by Pistorius and his vacillation between putative self-defense, private defense, non-pathological criminal incapacity, pathological criminal incapacity where they sent him for mental evaluation, etc., does not really help. So Oscar comes across as someone who doesn't really know what it is that he wants to tell the court. Now, to Oscar's advantage is the fact that he is the only person who knows what transpired, albeit, as I said earlier, he is under no obligation to tell that version to anyone. Now, fortunately, our courts, or unfortunately, for people like Reeva Steenkamp's family, our courts don't deal with the truth. They're not trying to dig away to find the truth. Because quite frankly, with the right to be presumed innocent, you're almost never ever going to know what happened behind those doors on the fateful day of the 14th of February 2014. Now, many in the public domain are saying he's guilty, he's not. He's innocent. Why would he go and shoot Reeva Steenkamp? Why? The world was his oyster. He would have received so much money, etc., etc. All that blah, 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 including what I'm saying here today, is not going to influence Judge Masipa. That court is concerned with legal guilt, not moral guilt. Moral guilt is between Oscar, his reverend, and God. That's all. He doesn't owe you an explanation, doesn't owe me an explanation, and he is under no obligation to say anything to anyone. Now, the defense in their lucky packet, because it's a competition of lucky packets. Gerinel says 1, premeditated and pre-planned murder. Failing which, just murder. Failing which, murder of the fictitious intruder. Failing which, culpable homicide. On the other hand, the defense are saying, no, all 4 counts. No, no, no. Oscar Pistorius is just not guilty. Not guilty, my lady. He's not. And if indeed you are inclined to say that he is guilty, then surely non-pathological criminal incapacity. So he wasn't responsible. Not that he suffers from a mental illness or mental defect. That is what the defense are saying. And at the very least, they are also saying culpable homicide, if the court really wants to go there. Now, this Ngubane decision that I spoke about, that has been criticized by legal scholars, etc., and I don't know which category I fall into. I know I'm learned in the law, at least, but I criticized the learned judges of the Supreme Court of Appeal as well. Now, in this decision, what happened is the judges, an extract from the decision says, a man may foresee the possibility of harm and yet be negligent in respect of that harm ensuing, example by unreasonably underestimating the degree or possibility or unreasonably failing to take steps to avoid the possibility. So you become intoxicated, you become angry, you take a knife, you cross the street, and you stab your girlfriend multiple times. No intention to kill, intention to be negligent. Now the decision, as I said, has been widely criticized, and if Judge Masipa relies on the principles enunciated in the State versus Ngubane, we are on a slippery slide downwards. And then Gerinel will have to jump in and say, apply for leave to appeal, my lady, back to the Supreme Court of Appeal, because they are the only people who are not bound by this decision. If they revisit this decision and say, well, that day we weren't quite there, we revisit our decision, that decision is wrong. Or if they say, no, 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 definitely, that is how it rolls, then Gerinal can continue, or the state can continue, and appeal to the Constitutional Court. So that once and for all, this decision of the state versus Ngubane can come under serious constitutional scrutiny. We've just come out of Women's Month in South Africa, which was August. And it's September, and here is another woman. Senseless killing, pointless, senseless killing. And the victim in Ngubane, an unknown black woman. There was no media, there was no hype. Her partner got away. 7 years. 7 years. He decided to drink, decided to get drunk, but none of that really mattered in the end. Now then there's another decision that has been applied over the years, and that is Rex versus Blom. And that was when the Supreme Court of Appeal was still the appellate division. And this decision talks about the cardinal rules of logic and inferential reasoning. At the heart of it, it says that the inference sought to be drawn must be consistent with all the proved facts. Not just all the facts, all the proved facts. If not, an inference cannot be drawn. The proved facts must be such that they exclude any other reasonable inference from them, save for the one sought to be drawn. If the other reasonable inferences are not excluded, then there must be a doubt whether the inference sought to be drawn is indeed correct. Now, it is true that the defense relied heavily on this decision, and I suspect that in the event of Oscar being found guilty of murder, and I say there appears to be sufficient evidence to find Oscar guilty of the crime of murder, the only other real chance Oscar Pistorius would have, that is if Ngubane doesn't mess this pot up, would be to challenge the constitutionality of this decision and say perhaps it violates the right to be presumed innocent. But for now, they're relying on the decision because, or the defense relies on it, because they want the court to basically say, well, the state didn't prove much. The state doesn't know what happened. They didn't really go to that extent. Now, Oscar wasn't charged with premeditated murder as contained in the Criminal Law Amendment Act 105 of 1997, which is commonly known as our minimum sentencing legislation, where premeditated murder carries life imprisonment. Now, all those who love juicy stories are already asking, will Oscar do life? No. No such luck. He wasn't charged in terms of that legislation. Had he been charged, he would have had to be warned that this is the possible sanction that he would face. Now, even if Gerinal had charged him with premeditated murder as contemplated in the Criminal Law Amendment Act of 1997, it makes provision for substantial and compelling circumstances, which allows the court to depart from the prescribed minimum. Ngubane was 10 years, reduced to 7. So it doesn't look like much will happen. The sentence will not be as cumbersome as some people hope it would be if Oscar Pistorius is indeed found guilty. Now, as I close, in part 3 of the book of the City of Ladies by Christine de Pizan, Lady Justice joins with Christine to add finishing touches to the city, including bringing in a queen to rule the city. Now, Riva Steenkamp was a law graduate, a woman who died a senseless and futile death. And I thought it apt to end with the oft-quoted aphorism from Rex versus Sussex Justices, ex parte McCarthy. Not only must justice be done, it must be seen to be done. As I said in the introduction, I am Brenda Wardle. I'm a legal analyst, but I'm also the author of the book To Kill a Fragile Rose, the state's case against Oscar Leonard Carl Pistorius. Keep your eyes and ears out for the date of release of this very, very important book, which will no doubt titillate you. For now, from a not so sunny but usually sunny South Africa, toodles!
And cut.